you.
Thank you. All right. Call the meeting to order and open up with a roll call. Commissioner Baker,
Present.
Commissioner Bluestone,
Here.
Commissioner Carruthers,
Here.
Commissioner Castillo,
Here.
Commissioner Solomon,
Present.
Commissioner Villanueva,
Here.
and the chair is here. So everybody's here. Next item is approval of the agenda. Is there a motion and a second?
So moved.
Second.
Okay, is there any objection? Hearing none, the agenda is approved. Next matter is the approval of the minutes of the special meeting that was conducted on May 11th of 22. Is there a motion and a second?
So moved. Second.
Okay, is there any discussion or objection to that approval, to that motion? Hearing none, we'll go to item number 4. Jeremy, I'll turn it over to you.
Okay, thank you, Chair. Good morning, Commissioners. Before we begin with our substantive work, I just want to introduce some new members of the team to you. So first, I'd like to introduce Suha Musa, who is the Communications and Administrative Manager. She has taken over from Sunny, who you'll remember. Suha is from the Twin Cities area. She came to UNM on scholarship, and we've persuaded her to stay in New Mexico, at least for a little while. She's been with us for 2 weeks, and I have been so impressed with Suha. She is very reliable and very, very intelligent, and this is a great hire for the commission. So welcome, Suha, and I look forward to the commissioners getting to know you and working with you.
Yes, welcome, and we are
Welcome.
glad, we're
Yes,
glad you're
welcome.
here. Thank you.
Okay, next, I'd like to introduce the UNM summer law students that we have with us this year as our summer associates. Miguel and Xavier, if you could turn your cameras on. So Xavier and Miguel both just finished their 1L year. Xavier is from Albuquerque, went to Brandeis for undergrad, and came back to UNM for law school. Miguel is a Talseño, went to Temple for undergrad and came back to UNM for law school, and they're doing great work. They're helping us with research that we need to build out our information in the agency, but they're also doing real substantive work. So Xavier is helping KC on a motion for summary judgment. Miguel is helping me on an advisory opinion, and we load them up with all kinds of sundry requests, and they're handling everything we're giving them. We also kind of read together the lawyer staff and the law students cases that are coming down from the Supreme Court and from the Federal Court of Appeals that matter for our disclosure statutes, that are large democracy holdings, that are administrative law holdings. And it's really enjoyable for the attorney staff to kind of do that with the law students. So Xavier and Miguel, thank you very much for spending your summer with the Ethics Commission, and I hope the commissioners can see a little bit of your work as well.
Welcome.
Yes. Likewise, welcome everybody. Thank you for being here. Okay, then on to item number 5, the advisory opinion number 2022-06. Becky.
Good morning, Chair and Commissioners. I'd like to present to you advisory opinion 2022-06. We received a request regarding what, if any, limitations on communications there are between legislators and lobbyists employed by the same entity in a couple different ways. 1, during sessions, 2, outside of legislative sessions, and 3, between legislators and board members or employees of that same entity. It's a pretty straightforward opinion. The answer is no, there are no ethics statute of limitations. The Lobby Registration Act does require reporting of expenditures to legislators, and the Governmental Conduct Act does require disclosure of conflict of interest. This opinion kind of sits on the base of two other state ethics opinions we've done, and I think it's mentioned in there. Advisory opinion 2021-07 and advisory opinion 2021-08. But I think it's straightforward, and I stand for any questions.
Anybody?
Yeah, I've got a question. What is the distinction between the requirement to disclose and the requirement to recuse? And the follow-up question is, if legislators are supposed to disclose, do we have any sense of how often they do, how consistently they disclose potential conflicts?
Your first question, Commissioner Baker and Chair. The difference between the requirement to disclose and the requirement to recuse is that disclosure is required under the Governmental Conduct Act and recusal is not. So that's the main difference. However, we do recommend voluntary recusal if there is a conflict of interest to prevent a violation of 1016(3)(a). The second question, again, can you repeat it? Actually,
Yeah,
it's been out of my head. Sorry.
That's okay. How good is our legislators, how consistent are legislators in disclosing conflicts?
And Jeremy can correct me if I'm wrong, but I don't think we have a very good grasp on that at this time. I think there's not, as far as I'm aware, there's not really a procedure to disclose in either the House, in either of the Senate or House rules. We have recommended that they put that in place so that will be standard, but I don't believe at this time we have a good grasp on that. Jeremy, do you have another take on that?
So Chair and Commissioner Baker, in the past, the Ethics Commission has noted that the Governmental Conduct Act requires disclosure of conflicts of interest, but there is no House rule or Senate rule that elaborates on that requirement as of now. In a past advisory opinion, the Commission has suggested that would be a rule that the chamber should adopt for themselves. And the Commission has pointed out that ideally the disclosure would come before a legislative act in the context of a conflict of interest.
All right. Thank you. Anyone else?
Yes, I guess I have a related question. Can you hear me okay?
Yeah.
Okay. To the extent that a legislator has the opportunity in the financial disclosure form to disclose any other interest that he or she thinks should be disclosed that may be relevant to the public, for the public to know about, do you think it would be helpful to note in this opinion that it's encouraged that legislators should use that opportunity to disclose, if they haven't otherwise disclosed it, the entity with whom they are employed or work who does lobby before the legislature?
Commissioner Bluestone, Chair, I do believe that is a requirement from the Financial Disclosure Act that you list your employer, and if you have any contracts with any entity, I think it's greater than $5,000. So I think that's what is required under the Financial Disclosure Act, and if you would like and want to direct us to put in an additional paragraph relating to that, I'd be happy to do so.
Well, what do you think, Becky? I mean, I think to the extent we can encourage disclosures. I think you're absolutely right about what's required. But it might be helpful to note that that opportunity is there, and this could apply certainly for contracts less than $5,000. But to encourage as much disclosure as possible, I think would be helpful.
I think that, our whole position is that more disclosures is better. So that would be consistent with that. And I do believe, and Jeremy can touch on this in more depth, but I do believe that the Financial Disclosure Act bill that has some changes to the Financial Disclosure Act that was introduced last year addresses some of those things. But Jeremy, I would defer to you on that specifically.
So Chair and Commissioner Bluestone, that's a footnote that we could add to this advisory opinion. I think it'd be helpful to, just to have a more complete presentation on how members can respond to conflicts of interest. The advisory opinion request was really about limitations on communications between members and others. So we don't want to stray too far from the advisory opinion request when we answer it, but a footnote that adds that the Financial Disclosure Act is another available opportunity for the disclosure of conflicts of interest is easily done.
Okay, well, if that's not too much of a problem, I would like to make that request. I think it could be helpful in our interest of full disclosure always.
Thank you. Anyone else, commissioners? Okay. So with the addition of the footnote as discussed, which I'm sure Becky is quite comfortable knowing exactly how to place Scribner on that, is there a motion and a second to adopt the advisory opinion and let it issue?
Move to adopt the advisory opinion as revised.
I'll second it.
Thank you. Moved and seconded. Any other further discussion? Commissioner Baker,
Yes.
Commissioner Bluestone,
Yes,
Commissioner Carruthers,
Yes.
Commissioner Castillo,
Yes,
Commissioner Solomon,
Yes.
Commissioner Villanueva,
yes,
and chair votes yes. Thank you. Let the opinion issue as revised. Thank you, Becky. Next, item number 6, advisory opinion 2207, Jeremy.
Okay, thank you, Chair. Commissioners, this is a longer advisory opinion, so I'm going to introduce it in parts. The first part is I'm going to introduce the question that this advisory opinion seeks to answer. Second, I'm going to introduce how the opinion answers it. And then third, I'm going to say a little bit about what the advisory opinion does not conclude. So first, we start with the proposition that in New Mexico, business entities can make contributions to candidates. And we know that because in section 119.34.7A of the Campaign Reporting Act, the statute limits persons to giving at most $10,400 to a statewide candidate, and then $20,800 to a gubernatorial candidate per election cycle. The limitation is on persons, and the Campaign Reporting Act defines a person to be an individual or an entity. And so we infer from the definition of person and from the contribution limitations that the Campaign Reporting Act in New Mexico allows business entities to make contributions to candidates. Now, the Campaign Reporting Act in the same section also includes an attribution rule. And it's as follows: all contributions made by a person to a candidate, either directly or indirectly, including contributions that are in any way earmarked or otherwise directed through another person to a candidate, shall be treated as contributions from the person to the candidate. This attribution rule is really about figure out when a contribution should be attributed to a person for the purposes of aggregating their total contributions and applying the contribution limits. Now, here's where it gets interesting. Business entities are legally separate from the individuals that control them. That's a foundational principle of corporate law. But business entities can only act through individuals. They're fictive persons. They can only act through individuals. And because the CRA's attribution rule uses the word person, all contributions made by a person to a candidate, the attribution rule applies to both entities and individuals. It contemplates, because it uses the word person, that there are some circumstances in which a business entity's contribution will be attributable back to an individual. And so the question that was presented is when, under what circumstances is a business contribution to a candidate attributable back to an individual? So that's the question presented, and that's why the question arises. The advisory opinion advises that in two circumstances, a business entity's contribution is attributable back to an individual for the purpose of calculating that individual's total campaign contributions. The first circumstance, the advisory opinion calls a conduit contribution. And a conduit contribution is when an individual gives money to the business entity and the business entity gives the money to the candidate. We know that conduit contributions, where the individual is the source of the funds and directs the funds through a business entity to the candidate, are captured by the attribution rule, because the attribution rule says that indirectly made contributions, and then quote, including contributions that are in any way earmarked or otherwise directed through another person to a candidate, shall be treated as contributions from the person to the candidate. So conduit contributions, or straw man contributions, as the case law calls that kind of contribution, is one kind of contribution that, even though a business entity makes it, it's ultimately attributable back to an individual for the purposes of calculating that individual's aggregate campaign contributions and applying the limits. But that's not the only way that, or the only circumstance under which contributions made by a business entity are attributable back to an individual. There are other ways under the statute that an individual can indirectly make a contribution to a candidate through a business entity, using a business entity, that are attributable back to that individual. And we know that there are other ways under the statute, because the clause in the attribution rule, including contributions that are in any way earmarked or otherwise directed through another person to a candidate, that clause modifies the word indirectly in the statute. And the Supreme Court has repeatedly said, when the legislature uses the phrase including something, that it does not mean that whatever follows including is meant to be exhaustive of whatever is being modified. That in fact, there are other ways that whatever is being modified can be instantiated, can happen under the statute. So in the circumstance of this statutory provision, when the attribution rule uses the word indirectly, and then it modifies it indirectly with that including clause, we know that under the statute, there are other ways that a contribution can be indirectly made and attributable back to the individual, apart from conduit contributions. And so the second part of the answer is figuring out, well, when else would a business entity make a contribution that is really indirectly made by an individual and thus attributable back to that individual? And the advisory opinion offers the following: that when an individual necessarily controls the business entity and unilaterally causes that business entity to make a contribution, that contribution is also attributable back to the individual for the purposes of calculating their total contributions and applying the contribution limits. That's what the opinion calls a controlled contribution. The difference is a conduit contribution, it focuses on the source of the funds, that an individual is ultimately the source of the funds and then moves the funds to the business entity, and then the business entity gives the funds to the candidate. That's one way of making where the individual indirectly makes a contribution through the business entity. The other way, the controlled contribution, is where the individual isn't necessarily the source of the funds. The business entity might hold the funds. But what's distinctive is that the individual necessarily controls the business entity and unilaterally causes the business entity to make a contribution to the candidate. In that circumstance, under the statute, that individual has indirectly made a contribution using the business entity. And so the advisory opinion offers that in each of those circumstances, the contribution by the business entity is ultimately attributable to the individual for the purposes of calculating that individual's contribution limits. Now, the third part, what is this opinion not saying? A few things. First, the opinion is not saying that every contribution by a business entity is attributable back to an individual. It's only in circumstances where the individual necessarily controls the corporation, the business entity, the LLC, and unilaterally causes the business entity to make a contribution, that the contribution is attributable back to the individual. There's going to be many circumstances where business entities make contributions where it can't be said that one person necessarily controls the business entity and one person unilaterally caused the business entity to make a contribution. So the advisory opinion is in no way suggesting that business entities, that their contributions will always be attributable back to an individual. It's only going to be for certain businesses that are necessarily controlled by one individual and where that one individual unilaterally makes a contribution, causes the business entity to make a contribution. Second, the advisory opinion is not saying that business entities cannot make contributions. It's not saying that at all. It's only saying under the few circumstances where a contribution is attributable back to an individual. Now, there are some circumstances where the attribution rule might impose liability or some remedies on the individual. So for example, if the individual has already given a maximum contribution, say to a gubernatorial candidate of $20,800, and then the individual either makes a conduit contribution through a business entity or a controlled contribution using the business entity, because the business entity's contributions are attributable back to the individual, that individual will have exceeded the contribution limits. And the remedy in that circumstance is that the individual is subject to a fine and the campaign would have to forfeit the contribution. That's only in the narrow circumstances where the individual has given a maximum contribution. In circumstances where the individual hasn't made a contribution at all, the attribution rule in no way is going to prejudice the ability for the business entity to make a contribution without prejudicing the individual. So again, to sum up that part, this advisory opinion is not suggesting that a business entity cannot make a contribution. Only in a few narrow circumstances where the individual has already given a maximum contribution will this advisory opinion kind of impose remedies on the individual. And then last, there's going to be a lot of circumstances that are more complicated than the test and the prototype that the advisory opinion suggests with respect to controlled contributions. The advisory opinion doesn't really provide any guidance on circumstances where more than one person controls the business entity. And so where more than one person causes the business entity to make a contribution. It doesn't speak to circumstances, for example, where there's a shareholder agreement, where there's multiple shareholders, but one shareholder is the managing partner, and the managing partner's decisions can't be countermanded by the other shareholders or the board. And the managing partner decides to make a contribution through the business entity. The advisory opinion doesn't speak about that circumstance, and the application of the test that the advisory opinion outlines to that circumstance, it would depend on the shareholder agreement. It would depend on the facts of that next case. Similarly, the advisory opinion also doesn't provide any advice on pro rata attributions. For example, where there's a 3-member partnership and the partners make a vote to give a contribution to a candidate. Whether or not that contribution is pro rata attributable back to the partners, this advisory opinion doesn't speak to that. That's the next question. So in some ways, this opinion opens the door to several other questions that are next in line. You can't answer all those questions in the scope of one opinion. But what this opinion does is it makes clear that under the statute, under the attribution rule, because it uses the word person, because person under the statute is defined to include individuals and entities, the opinion offers the 2 circumstances in which the business entity's contributions will be attributable back to the individual. And so, Chair, with that, I submit the advisory opinion to the commission for its consideration.
Thank you. Let's entertain a motion in a second and then go into discussion. Is there a motion to adopt the advisory opinion?
So moved.
Is there a
Second.
second? Okay, it's been moved and seconded. Discussion. Commissioner Baker, anything?
Yeah, a couple of what ifs. As I understand the law, Jeremy, if John Brown wants to give $20,800 to the governor for her reelection, that's allowed. And if John Brown LLC, of which John Brown is the sole member, also wants to give $20,800 to the governor, that would not be allowed. Is that correct?
That's roughly correct. Let me say it more technically correct.
Okay,
John Brown LLC's contribution would be attributable to John Brown. And thus, when it's attributed, John Brown will have exceeded the contribution limits and would be liable for a civil penalty, and the campaign would need to forfeit or would be liable for forfeiture of the excess contribution.
all right. And my second hypothetical, Elon Musk, $20,800 to the governor's reelection campaign, that's allowed. And if Tesla gives $20,800 to the governor's reelection campaign, presumably that would be allowed because Tesla has multiple shareholders and has a board of directors. But unless somebody was able to prove that Elon Musk flexed his muscles and said, this is going to happen, or bad things are going to happen to the rest of you, presumably that contribution would be allowed.
So Chair and Commissioner Baker, that's correct. Unless the facts were that Elon Musk diverted $20,800 of his own funds through Tesla to make the contribution, in which case it would be a conduit contribution. Assuming that's not the case, and that Tesla has plenty of money in its own operating account to make contributions, the controlled contributions test under this opinion would not attribute Tesla's contribution back to Elon Musk.
Okay. And then finally, I mean, depending on what everybody else asks and what the conversation reveals, I might make a suggestion that you add another piece to this advisory opinion. And that last piece would be, this advisory opinion does not answer the following question or questions. Just to make it a little clearer that this is a complicated issue, and this advisory opinion is specific to a particular question, but there's a lot of unanswered questions that this opinion does not address.
Chair, Commissioner Baker, I'd be happy to do so.
Thank you.
Commissioner Bluestone?
Thank you. Thank you, Jeremy, for the excellent work and all the hard work that's gone into this opinion. I think it's very thorough, and I think it's very well done. And I agree with most of it, but I still have a problem with a part of it. I think we start from the same position, that the statute is clear that a person is defined as either an individual or an entity, and that the limitations on contributions apply to those separate individuals or those separate entities. I also think that the analysis about the conduit improprieties and unlawful contributions is absolutely correct. I think there are a lot of ways that this can be done. And I'm concerned, for example, about circumstances where a corporation gives a maximum amount, and then the corporation, directly or indirectly, provides money to employees and maybe to cover the spouses of employees to give money as well to the candidate, either by giving a bonus payment or by providing some other indirect payments to the employees for cars or vacations or whatever it might be. So I think that the attribution rule in the statute is a good one, and tries to cover all kinds of attempts that may be made to skirt the proper limitations that have been placed in the statute on the maximum contributions. The problem that I have with the opinion, and I respect it tremendously in terms of the analysis that's been done, but I like the result that Jeremy has explained and that the opinion puts forward, that an individual should not be able to skirt or evade the contribution limits by giving the maximum amount individually and then going through a separate entity in a way to avoid the contribution limits. But I don't think our statute says that. And I think in the other states that we've been advised about that have done this, they've done it explicitly. They've said that no wholly owned corporation can make, that the contributions of a wholly owned corporation or entity shall be attributable to the individual. I think that's a way that it can be done and it should be done. But I don't think our statute has done that. And I would be fully supportive of us supporting an amendment to make that kind of a prohibition explicit in our law and conform to the other states we've been advised of, California and others that have done this. But I think to read the statute as it is, where it says that entities are treated separately than individuals, and to try to merge this together for an unlawful contribution goes against the statute's own words that a person is defined as an entity or an individual. Now, having said that, if somebody has a wholly owned corporation or a wholly owned LLC or whatever, as long as that separate legal entity, separate legal identity is a valid ongoing concern, and it does more than just make campaign contributions, I think we have to wait for our legislature to be explicit, like the other states have done, that you can't make separate contributions through them. But if it's not an entity that's set up just to make contributions, you know, where it's an obvious scam and sham to evade our contribution limits, if it's a separate legal entity, whether it's a corporation or an LLC that has an ongoing existence and is a legal entity, just because it's 100% owned by an individual, I don't think our statute says that those entities cannot also make contributions when the individual has made the maximum contributions. So I like the result that it gets to, but I think it's a stretch of what's currently in our statute that treats persons as separate individuals and entities. And so while I fully support the conduit analysis part of it, I think that the controlled corporation part of the analysis is contrary to what the statute itself directs. And so if it's appropriate at some point, I would be happy to make a substitute motion to request that the opinion be revised to focus on the conduit analysis part of the opinion and to talk about the ways in which that can be abused and that we would be enforcing it. But I think to attribute wholly owned corporations or LLCs the same as individuals, where they have separate legal identities, I think goes too far and beyond what our statute currently provides. So I would respectfully disagree with that part of the opinion.
Thank you. Commissioner Carruthers?
Well, first of all, I'd like to ask, Mr. Chairman, ask Jeremy to kind of respond to that. I thought it was rather clear in my reading of this that a wholly owned corporation would be treated as the individual, a contribution be attributable to the individual. Is that not true or not, Jeremy?
So Chair and Commissioner Carruthers, from my understanding of Commissioner Bluestone's comments, where we disagree is that the way that the staff reads the attribution rule is that the word indirectly, which modifies the verb made, indirectly made contributions, capture contributions that go beyond conduit contributions. And the kind of legal analysis of that is, again, because this including phrase, which is roughly including conduit contributions, shall be treated as contributions from the person to the candidate, that including phrase, because it modifies indirectly made contributions, and it provides an example of indirectly made contributions as conduit contributions, that the statute indicates that there are other kinds of contributions that are indirectly made contributions that are attributable back to the individual. And the advisory opinion tries to fill in, well, what are those other indirectly made contributions that are conduit contributions? And the answer, I think, comes down to control, that if the individual necessarily controls the business entity and no one else is in control of the business entity, and the individual unilaterally causes the business entity to make a contribution, then that contribution is attributable back to the individual. In some ways, control, I think, is the larger and the dominant concept as opposed to the source of the funds. Because if an individual controls the business entity, then the individual can really move the money around however to make it the case that the source of the funds is either with them or with the business entity or with some third party. But what really is the dominant and driving consideration here, I think, is control. And if the individual is necessarily and unilaterally in control of the business entity, as they would be, for example, in a lot of conduit contributions, then that control is essentially how they indirectly make a contribution. And because it's an indirectly made contribution under the attribution rule, it's attributable back to the individual.
Well, I think we received some information the last time we discussed this about some of the contributions that have been made to candidates, I think in particular in the governor's race. And I know some of those corporations and their owners. In one particular case, I'm relatively sure that the corporations that were contributing the money were solely owned by the person that also made a contribution of his own right to this particular candidate. And then that set of corporations that that person owns may have made as many as 2 or 3 contributions. I see that as clearly attributable to that particular owner. So I think we come down to the question of control and how that decision was made. So I would disagree with Stuart about having to modify the opinion so much as to asking that going forward, these clarifications need to be made going forward to properly determine attribution. And I think we need an action forcing event to cause the legislature and or others of the courts to determine what's attribution. I'm not a lawyer, and therefore I'm not going to be able to debate with Commissioner Bluestone the intricacies of the statute. But I do think there is some uncertainty here that I can't give you an answer to, but we as a commission ought to recognize that clarification is required, and in issuing this opinion, make that part of the issuance to say these clarifications are necessary going forward, whether it be by the legislature or by the courts.
Thank you. Commissioner Castillo.
There we go. I also agree with Stuart that the work that has gone into this opinion is tremendous. And I thank Jeremy and I thank the staff. My biggest problem is we're getting into pretty much a can of worms because there are so many examples, as Jeremy pointed out, that we are not covering here that can have some of the same problems. And when I look at this, to me, it seems like it's a better approach to look at this as a whole and have the legislature look at it. Because if the courts look at it, it's going to be piecemeal. And when I go back to it, again, I have no problem with the conduit idea, where the source of funds is really the person. And I am concerned, though, about the controlled part of the opinion. I went back, the definition of person was put in the statutes in 1995. And then the definition that we're working with today, or the language we're working with today, was part of a law that was passed in 2009. And then in 2010, the Attorney General did an advisory opinion. And in that advisory opinion, the Attorney General specifically said that solely owned corporations, corporations owned by one person, could go ahead and make a contribution, and the corporation could make the contribution. And that has been, I think, relied on all these years. It's in the part of the statute where you look to see what the statute says, the annotations. And I agree that an attorney general's opinion is not law, and that we can go ahead and, as a ethics commission, we have our goal is to make sure that the Campaign Contribution Act is fairly enforced and interpreted. I just don't interpret it to cover this particular situation the way the opinion covers it. Now, as far as I agree that all the different scenarios that Jeremy has pointed out, when you have a corporation that is controlled by more than one person, but the people that control it, 2 or 3 people, make that decision. In other states, for instance, LLCs, the statutes say that you need to look behind the LLC and see what percentage the LLC members own of the corporation, and then their portion of the contribution is reduced by that much or attributed by that much. And these are all kinds of things I think need to be thought about. And as far as I said, the event, the action forcing event, I agree with Governor Crothers. We need to have an action forcing event, but I don't think it's this section of the opinion. I think the other part of the opinion is fine, but we need to talk to the legislature and maybe prepare legislation ourselves to address not only this question, but all the questions that are related to it. So that's what I think of this particular opinion.
Thank you. Commissioner Solomon?
I don't know if I can add very much to everything that has been suggested. I do like, to start off with Jeff's suggestion that there be a footnote added. And I think that's where probably all the discussion kind of has emanated from, is that we're not addressing, trying to address all the issues with regard to this opinion. So I think the analysis that has been done is adequate for the moment. I kind of hesitate when we start looking at this in terms of with our legislative lens on it, but I know that that's what it needs. And I think that suggestion can be made through other means, other communications. So I'm with regard to this particular opinion, I'm good to go with it. Thank you.
Thank you. Commissioner Villanueva?
Yes. I would like to say that I'm not bothered at all that this advisory opinion does not, in its current state, address all the possible circumstances that can come up. I subscribe to the rule for 80, which basically states that if you can start with a rule that covers 80% of circumstances, it's a good start. When you have, then you would have some subsequent scenarios that come up that will help you refine the rule. The rule becomes the rule for 85%. And that's the way I believe that it could evolve. I think this is such an important issue and we have an opportunity to make a start. I think there's good law behind it and I think there's good reasoning. And I think it's our opportunity to do something that the Ethics Commission was asked to do by the people of New Mexico. I think it was a very bold move for Jeremy to make, and I think it's an important one. And it'd be interesting to view this from the perspective of what a common citizen would see. So I would just like us to not be so steeped in the law and see and think about what it is that the common citizen sees. Does it make sense? I have a question about what a business entity is. I don't know if anybody can answer that question for me. Is a business entity simply a bank account, a separate bank account, or is it an establishment that's been operating for a year? Is it an establishment that is registered as a legal business with a license? I'm concerned that businesses can be, again, created on a whim, on a desire to make contributions. So I think we have to start somewhere, and I think Jeremy's advisory opinion is a good start. So I would support the advisory opinion as is. Oh, not as is. I'm sorry. I'd like the recommendation made by Jeff as well to make some amendments.
Thank you. And I agree with what you and Governor Crothers and the other commissioners have said, respecting what's there. I like the opinion. I think it is common sense. The law was once told to me as common sense is modified by judges. And there's a lot of truth to that, but I think there's an honoring and a respect of statutory construction rules. The easy connection for me is to issue the advisory opinion, which again, not unlike an AG's opinion, it doesn't carry the force of law with it. It is instructive and people can rely on it. It also does not prevent what both Commissioner Bluestone and Commissioner Castillo have said, and that's working with the legislature to work with it in a way which clarifies it more in line with what their preferences are. But doing nothing and going to the legislature doesn't make sense to me. It is a logical reading. The easiest thing in the world, the easiest example, is to look at a law firm or some sort of professional firm. It's an LLC and it's two different people exceeding the contribution limit, which is, I think we all agree is designed to do. And it dovetails nicely into what Judy said. You know, what is the Ethics Commission's purpose? I think if something is not clear, we can't create things out of whole cloth. I don't agree that that's what we're doing here. I think the entire opinion reads, it's a difficult chew, but it reads well, and it is in line with what I've always looked at as the rules of statutory construction and the rules of the English language. I think it's an obviation and in contrast to really what we're designed to do here. We issue an advisory opinion that gives people guidance. Somebody comes back and says, hey, this is what I thought I did in compliance with this in defense to an action. That's when you look at that. But again, it's an advisory opinion. There's nothing to suggest that we can't both issue this and pursue the legislature in their collective wisdom to make it less unclear, if that's the phrase. So I too support it. And to the point of an added footnote, I don't think there's any harm in that either. So is there any further discussion? No? Okay, I'll call the question. Commissioner Baker?
Yes.
This is, and I'm sorry, the motion needs to be amended to include the footnote you suggested. Is that where everybody is, I think?
Yes.
Okay, so there was a motion and a second. Do we agree to the modification to include the suggested footnote point?
Sure.
Yes.
Okay, Commissioner Baker on the modified motion.
Yes.
Commissioner Bluestone,
No, with all due respect.
Commissioner Carruthers,
Yes.
Commissioner Castillo,
Commissioner Castillo, you have to unmute.
Commissioner Castillo, you're muted.
Oh, yes. No,
Okay, Commissioner Solomon,
Yes.
Commissioner Villanueva,
Yes.
chair votes yes. We have this odd rule that requires, have we met the? Jeremy?
The motion failed for lack of.
Motion fails because we don't have the appropriate minimum, right? The construct is not adequate.
Mr. Chairman, can I make a substitute motion?
Sure.
And I'd like to make a motion that the staff be directed to revise the opinion to focus on the conduit analysis and to suggest how the legislature could amend the statute to make express the result that the opinion seeks.
Is there a second?
I second it.
Okay, there's a motion, a second. Any discussion?
Yeah, Mr. Chairman, would Commissioner Bluestone restate the motion?
Yes, Governor, the motion is to request that the staff revise the opinion to focus on the conduit part of the analysis and to address the controlled part of the analysis with suggestions on what the legislature could do to make explicit the result that this opinion seeks to achieve. In other words, I like the result of the analysis, but I don't think our statute provides it. And so the request would be for a revised opinion to focus on the conduit analysis, which I have agreement with, and as I understand Commissioner Foy Castillo, she does too, but to revise the controlled part of the analysis to indicate what the legislature could do to make that explicit.
Mr. Chairman, I guess on the conduit analysis, it is an assumption that I, owning a corporation, then put my own money into the corporation to give to a candidate. I think that's what the conduit opinion would be. That's not the way it works. These people own these companies, spend the company's money doing it. They don't spend their own money doing it. And as a consequence, I think the conduit thing is probably not as important and interesting as the fact that people who control corporations actually give money, not their money, but the corporation's money.
If I can ask a question, Jeremy, it would seem to me that, well, at first blush, not a bad idea, but it also becomes carving up a different animal, and we end up with a camel that was originally designed to be a dog. And I'll defer to you on that, but I don't know how that parses with logically the work, but I have some concerns about it.
So Chair and Commissioner Bluestone, I appreciate Commissioner Bluestone's motion, but respectfully, I think that the commission ought not go that direction, because I believe that maybe now with this analysis being published and this discussion being public, it might invite the action forcing events of a complaint that would test the controlled contribution theory. And if we receive that administrative complaint, I wouldn't want to see the commission tie its hands to an advisory opinion that is only with respect to conduit contributions that would be binding on a hearing officer. I would like a hearing officer to have the opportunity to adjudicate that complaint under the full facts presented at a hearing without there being binding precedent from the commission on that administrative case. That's a point I've given some thought to. I again, respectfully, I appreciate Commissioner Bluestone's motion in that regard, but that's how I see it.
Okay. Anybody else? All right. So there is a motion before the commission to direct the staff to issue a revised advisory opinion focusing on the conduit portion of it only. And I don't know if it was part of the opinion or as a secondary bit of work to suggest possible legislative fixes. I don't know that you want that in the opinion, Stuart, but I may have misheard that.
Well, that was my initial thought. And let me emphasize that I think that our highest duty is to the Constitution and the laws. And I am concerned that we can't issue this opinion because, in my view, it's contrary to what the law expressly provides right now. So I was trying to find a way of going forward with the part of the opinion that I think we all agree with, which is that you can't use a corporation or an individual as a conduit to evade the contribution limits. And so if it's cleaner for consideration now not to get into legislative recommendations for the future, I'll limit the motion to just have the opinion be revised to address fully, as it does in significant part now, the conduit analysis of when contributions are improper because they are done as conduits between individuals and entities. So that's the revised motion, and we won't discuss.
Thank you.
the
Okay,
legislation.
that's clear. That answers my.
Mr. Chairman?
Commissioner Castillo, are you willing to amend your second to?
Yes, I am.
Yes, Commissioner Carruthers?
Mr. Chairman, I just have to reiterate that conduit's not the problem. That's not the problem. And I'm looking around to see how many of you run for office. Perhaps several of you have, but the corporation's actually giving the money is the problem, not the owner of the corporation giving money to the corporation to give to the candidates. That's not the problem whatsoever in New Mexico. It's corporations actually giving money because a person who owns or controls that corporation says that they want that to happen. And I looked at the data that we received last time, and I know some of these corporations, and I know that's what happened because they're solely owned by an individual or an individual's family. So I don't think we're addressing the problem at all, but that's just a comment.
Thank you. All right, we'll call the question.
I have a question. Is Jeremy saying that he doesn't want any opinion?
I
Chair,
believe that was the preference. So in order not to pin us into a corner, if I can paraphrase that.
Chair.
Jeremy, answer for yourself.
Yeah, that's correct. I think right now it would be better for no opinion to issue so as not to bind a hearing officer in the event the commission receives an administrative complaint along these lines.
Okay, Commissioner Baker, your vote?
The issue is Stewart's proposal that the
Correct.
opinion be limited.
That limit the advisory opinion to direct the staff to issue and for the commission. Well, I guess we would have to see what the revised draft looked like, but it anticipates that the commission would approve extracting that portion of this opinion relative to the conduit discussion.
Right, and the way I would phrase it is, with all due respect to Stewart, this is the half a loaf proposal,
Okay,
and I vote no.
thank you. Commissioner Bluestone,
Yes,
Commissioner Castillo,
How about-
Yes,
Carruthers, I'm sorry, Commissioner Carruthers,
No,
Commissioner Castillo,
yes,
Commissioner Solomon,
No,
Commissioner Villanueva,
No,
and chair votes no. So I think the motion fails, correct, Jeremy?
Correct. It fails for lack of two Republican.
Right. Same thing, only different. Yeah. Okay. All right. Are we finished with that item?
Yes, sir.
All right. Go to item number 7, which is the overview of 2022 financial disclosure filings.
Okay, thank you, Chair and Commissioners. This is to update you on a project that we have been working on for some time to try to improve the current state of the financial disclosure laws in New Mexico. I've presented on this before you for several meetings dating back well over a year and a half now. We have two projects to improve the Financial Disclosure Act in New Mexico. The first is the Disclosure Act, which is a bill that overhauls the Financial Disclosure Act and would improve the substantive disclosure requirements in our financial disclosure statutes. It's a repeal and replace bill. It was introduced in the last session by Representative McQueen, Senator Tallman, Representative Garrett, and Representative Townsend. And I hope that we have the opportunity to introduce that same legislation before the Courts, Correction and Justice Interim Committee this summer. That's the first project to try to improve the financial disclosure laws in New Mexico. But the second project is really to try to ensure better compliance with the financial disclosure statute that we currently have, the Financial Disclosure Act. In that regard, the commission has done a lot of work over the past year and a half to try to improve compliance. So one thing that we did, and before the State Ethics Commission existed, I don't think that this was ever done. We actually tried to figure out every official in the state of New Mexico that is required to file an annual financial disclosure. That's a project that we contracted with Paul Biederman on. Walker put a lot of work into that project, as did Sonny, as did I. And we developed a kind of large spreadsheet that details every office that in the state of New Mexico under the Financial Disclosure Act is required to follow disclosure. That's about approximately 650 offices. The commission also issued an advisory opinion that last year that clarified who a state agency head is under the Financial Disclosure Act. And you'll remember that opinion. So that's some of the work that we have been doing. That spreadsheet that we developed of the 650 offices, we shared with the Secretary of State's office, and the Secretary of State's office has been doing work to try to ensure voluntary compliance by contacting the folks on that spreadsheet to encourage them to file a financial disclosure. So at the end of January, when the financial disclosure statements were required, there were about, according to the Secretary of State's office, about 590 individuals that had not filed. So 650 roughly are required to file. By the end of January, 590 had not filed. And then the Secretary of State's office began its work using the spreadsheet we provided them and worked on with them to contact individuals, sending a notice in January, sending a notice in April, and to encourage folks to file their financial disclosures. And as a result of the Secretary of State's efforts, which I saw happening because people would get notices from the Secretary of State, and then in some instances, they would request an informal advisory letter as to whether or not their office fell within the scope of the Financial Disclosure Act, to which we answered. After the result of the Secretary of State's work, now approximately 150 individuals have still not filed their financial disclosures. So while that's not good, we have made some improvements in the process. We know how many people are required to file annual financial disclosures. The Secretary of State's office is using our work product to send notices. Those notices are to some extent effective. The Secretary of State's office is improving the CFIS system to the extent that they can, working with their vendor. And it's not a perfect system. Everybody knows that. And I suppose that the Secretary of State has also done a great job with the voluntary compliance piece in moving from 590 individuals who had not filed by the end of January to now approximately 150. And in executive session, I'd like the commission to take up the question, well, what enforcement action should the commission contemplate now with respect to enforcing the Financial Disclosure Act? Because it's still unacceptable that 20% roughly of those required to file financial disclosures in the state of New Mexico have not done so, and perhaps have not done so despite the Secretary of State's repeated notices. So there is a question of what to do going forward in that regard with respect to enforcement. And that's a topic that's on the agenda for closed session. But before that, I kind of wanted to provide you and the public in the public part of the meeting a kind of overview of where we are on the financial disclosure statute in New Mexico, financial disclosures, and what we're doing to try to improve from the kind of historical low with respect to this statute. So thank you, Chair.
Thank you. And we'll discuss that further as you've indicated under the adjudicatory proceedings. I think that covers the first open session. Is there a motion and a second to go into executive session?
So moved.
Second.
All right. Anybody opposed to that?
And Chair, because Mr. Cliff Reese is on, we want to make sure that motion to go into executive session is pursuant to the statutes.
I'm sorry, I will read it all in its entirety, so in case there is any confusion, that will be clarified. Is there a motion and a second to go into executive session pursuant to NM statute annotated 1978, 10-15-1H3 and 10-15-1H7?
So moved.
And
Second.
then second, all right. And to double down on that, Commissioner Baker,
Yes.
Commissioner Bluestone,
Yes.
Commissioner Carruthers,
Yes.
Commissioner Castillo,
Yes.
Mr. Solomon,
Yes.
Mr. Villanueva,
Yes.
chair votes yes. Okay, we will, as Walker sets up the room for us, take a 5 to 10 minute break and be back with you then. Thank you.
So thank you, Suha.
All right, thank you. We are back in open session and we will now look to, I believe we need to first go to item 8C, Jeremy. That has to do with the Financial Disclosure Act.
Yes, sir. We'll cover that in item 12 of the agenda.
Okay, thank you. I just had written it. I didn't want to, I want to make sure we didn't miss it. All right, let's look then for actions on administrative complaints, section 11. Jeremy,
Okay, thank you, Chair. I'd ask Walker to present the motion for 2022-01.
Thanks, Jeremy. Chair and Commissioners. I am looking for a motion to approve the settlement agreement entered into between myself and the respondent in the complaint number 2022-001 and issuance of an order in conformity with the vote, with the Commission's vote.
is there a motion?
So move.
Second? Anybody? All right,
I'm actually first on mute.
it's going to die for the lack of a second.
Second.
Thank you. All right. There's a motion, a second, to approve the settlement and issue the order in matter 2022-01. Any discussion? Commissioner Baker?
Yeah, I just want to briefly say that this is a settlement involving a complaint against Tim Eichenberg. A little over 25 years ago, I was general counsel to the Albuquerque Flood Control Authority. Mr. Eichenberg was elected to the board of directors, and as such, he was my client while I was general counsel. And I just want to put that on the record that I did have that professional relationship with Mr. Eichenberg more than 25 years ago.
And your vote on the motion?
I vote to approve.
Thank you. Commissioner Bluestone,
Yes.
Commissioner Carruthers,
Yes.
Mr. Castillo,
Yes.
Mr. Solomon,
Yes.
Mr. Villanueva.
Yes.
Chair votes yes, motion carries. B, number 2022-004.
Thank you, Chair. In this administrative matter, and I'll remind the Chair that he's recused on votes on this administrative matter.
Thank you.
The staff seeks a 90-day extension to continue the investigation pursuant to the State Ethics Commission Act.
Motion in a second.
So moved.
Second.
Thank you, Commissioner Baker,
Yes.
Commissioner Bluestone,
Yeah.
Commissioner Carruthers,
Yes.
Commissioner Castillo,
Yes.
Mr. Solomon,
Yes.
Commissioner Villanueva.
Yes.
Okay, and the chair refrains from voting for his recusal. Motion carries. C,
So Chair, in administrative case 2022-009, the staff seeks a motion for the commission to dismiss the complaint for lack of jurisdiction.
motion in a second.
So moved.
Second.
Thank you. Any discussion? Hearing none. Commissioner Baker,
Yes.
Commissioner Bluestone,
Yes.
Commissioner Carruthers,
Yes.
Commissioner Castillo,
yes,
Mr. Villanueva. Through you guys. Commissioner Solomon,
Yes.
Commissioner Villanueva. Judy, are you still with us?
He seems frozen.
I don't, sir. Yeah, she's got issues. And the chair votes yes, so the motion carries. We can record her vote when we get her back.
Okay, thank you, Chair. And the next administrative case, 2022-12. The staff seeks a motion to dismiss this matter because the Secretary of State has certified voluntary compliance with the Campaign Reporting Act claims.
Motion is second.
So moved.
Second.
Thank you. Any discussion? Hearing none. Commissioner Baker,
Yes.
Commissioner Bluestone,
Yes.
Commissioner Carruthers,
Yes.
Commissioner Castillo,
yes,
Commissioner Solomon,
Yes.
Commissioner Villanueva.
I am so sorry. Can you please repeat the motion? I didn't hear it.
It's the motion to dismiss on 2212 for the Secretary of State having certified voluntary compliance in this matter by the
Yes.
respondent. Thank you. And the chair votes yes. Commissioner Villanueva, although the motion to dismiss for lack of jurisdiction in 22009 carried, your vote was not recorded as you had frozen.
Yes,
Thank you. All right, so now we're on to E. Go ahead, Jeremy.
Thank you, Chair. And administrative case number 2022-013. The staff seeks a motion to dismiss the complaint because the Secretary of State has certified voluntary compliance with the CRA allegations.
Thank you. Motion is second.
so moved,
There's a motion is second. Any discussion? Hearing none. Commissioner Baker,
Yes.
Commissioner Bluestone,
Yes.
Commissioner Carruthers,
Yes.
Commissioner Castillo,
yes,
Mr. Solomon,
Yes.
Commissioner Villanueva.
yes,
Chair votes yes, motion carries.
Thank
Yeah,
you, Chair. An administrative case 2022-19. The staff seeks a motion to dismiss the complaint for lack of jurisdiction and to refer the claims to the Administrative Office of the Courts.
is there a motion is second?
So moved.
Second.
Any discussion? Mr. Baker,
Yes.
Commissioner Bluestone,
Yes.
Commissioner Carruthers,
Yes.
Commissioner Castillo,
yes,
Mr. Solomon,
Yes.
Mr. Villanueva.
yes,
Chair votes yes, motion carries. And administrative complaint 2220.
Thank you, Chair. In this administrative matter, the staff seeks a motion that the commission dismiss the complaint for lack of jurisdiction and refer the same to CYFD.
Thank you. Motion is second.
so moved,
Second.
Okay, any discussion? Hearing none. Commissioner Baker,
Yes.
Commissioner Bluestone,
Yes.
Commissioner Carruthers,
Yes.
Commissioner Castillo,
yes,
Commissioner Solomon.
Yes.
Commissioner Villanueva.
yes,
Chair votes yes, motion carries. Thank you. We'll now go to the next matter, which is administrative matters under the revised uniform law on notarial acts.
Rebecca, if you don't mind presenting the motions the staff seeks.
Thank you. Chair and Commissioners, in Re-Notary Public Commission of San Diego, 2022 NP03, the commission seeks you to issue a default order revoking Ms. Samoniego's Notary Public Commission.
So moved.
Second.
Thank you. There's a motion second. Any discussion? Commissioner Baker,
Yes.
Commissioner Bluestone,
Yes.
Commissioner Carruthers,
Yes.
Commissioner Castillo,
yes,
Mr. Solomon,
Yes.
Mr. Villanueva,
yes,
Commissioner Chair votes yes. Okay. Next matter is the Commission of Perez.
Chair, Commissioners, we would ask that you issue or vote to issue an NCA against Commission or against Perez's Notary Public Commission.
Thank you. Is there a motion a second?
So moved.
Second.
Thank you. Any discussion? Hearing none. Commissioner Baker,
Yes.
Commissioner Bluestone,
Yes,
Commissioner Carruthers,
Yes,
Commissioner Castillo,
yes,
Commissioner Solomon,
Yes.
Mr. Villanueva.
Yes.
Chair votes yes. And the final matter regarding Bratcher.
Chair and Commissioners, we would ask that you issue a default order revoke, not allowing Ms. Bratcher to apply for or receive a notary public commission until she has addressed her NCA.
so moved.
second,
Thank you. Any discussion? Hearing none. Commissioner Baker,
yes,
Commissioner Bluestone,
yes,
Commissioner Carruthers,
Yes,
Commissioner Castillo,
yes,
Mr. Solomon,
Yes.
Commissioner Villanueva.
Yes.
Chair votes yes. Thank you, Becky. Okay, the next matter, Jeremy, item 12.
Thank you, Chair. This is with respect to resolutions related to commission authorizations for civil enforcement actions. For the 155 persons that the Secretary of State office referred to the commission for failure to file a financial disclosure, I seek the commission's authorization to send demand letters to those individuals after the chair and I have the opportunity to speak with the governor's office about the matter, and then to file civil enforcement actions as necessary to ultimately enforce compliance.
so moved.
Second.
Any discussion? Thank you. Commissioner Baker,
yes,
Commissioner Bluestone,
yes,
Commissioner Carruthers,
Yes,
Commissioner Castillo,
yes,
Commissioner Solomon,
Yes.
Commissioner Villanueva.
Yes.
Chair votes yes. Thank you. Motion carries. Next meeting, who's got the calendar handy? The first Friday in August. I don't have one handy.
Chair, that would be August the 5th.
All right. Anybody want to look at we'd need, at a need to advance that to the 12th or otherwise? Are we still good with the 5th? Commissioners?
just remind the chair that August 12 is the State Bar meeting.
And
So if anybody was going to go to the State Bar instead of going to this commission, there'd be a conflict.
that would be August 12th, not August 5th. We're looking at.
so the 5th, we're still good on, we're still good on the 5th, right?
Right.
Okay, and we are hopeful we can meet in person, but that will be determined later. Is everybody good with that?
Yes,
Yes.
I had, in a passing conversation with Jeremy, suggested that once we get live, it would probably not be a bad thing if we were to actually meet in the Capitol sometime before the end of the year. I don't think that's a bad thing to do if we can meet in person at some point. Hopefully August will be a meeting in person, but let's see what happens with the numbers. We know we can do this because we've done it. I think we've had more Zoom meetings than we've had personal ones by now. Wouldn't bet on that, but I wouldn't bet against it either. So, okay, 8-5, place to be determined. Public comment. Walker, that's your bailiwick.
All right, yeah, and I'm eagerly looking forward to Suha taking over this role.
That's between you two.
I'd like to make public comment.
Let me go ahead and ask before folks jump in that you use the raise hand feature on your Zoom. So yeah, we've got one person already, two. All right, so let's just go through them. I'm going to go in the order that I'm seeing them, and the first to raise their hand was Mr. Tony Ortiz. So Mr. Tony Ortiz, I'm asking you to unmute yourself. Feel free to start your video if you'd like to show us all your face as well.
Thanks, Walker. Can you hear me okay?
We can hear you okay.
Yeah, very briefly, kudos to the commission for following up on compliance with the Financial Disclosure Act and the filing of financial disclosure statements. I'm currently working on a project where I'm looking at financial disclosure statements that have been filed by legislators in 2022. In addition to the issues that you've taken note of regarding noncompliance, I would just also state that the paucity of information and the general nature of that information set forth in the statements is pretty disheartening. So this is a step in the right direction. Obviously, the commission has also supported the Disclosure Act to replace the current Financial Disclosure Act. So these are all good proposals that I hope will gain momentum. Thank you.
Thank you,
Thank you,
Mr.
Mr. Ortiz. All right, next up, in terms of order of raising hands, we got Mr. Chris Meckles. Mr. Meckles, I'm going to ask you to unmute, start your video if you'd like, and then please feel free to make your comment.
Okay, can you hear me okay?
Yeah, we can, loud and clear.
Good.
Absolutely.
Okay. Well, members of the commission, I'm glad to address you. My interest is the Financial Disclosure Act. My interest goes back about 8 years due to my involvement with the Law Enforcement Academy Board. And at the Law Enforcement Academy Board, you know, they have about 9 members, and it has been every year just a cat fight trying to get financial disclosure from those members. Here's my conclusions after struggling with this problem for 8 years, which is still unresolved, is that one is I cannot get the Attorney General's office, which provides counsel to all these boards and commissions, and that's a major part of this financial disclosure group, to get their counsel, which they provide to these boards and commissions like the LEAB, to take responsibility for disclosures. It seems like the most natural thing in the world is that those councils should look every year to say, are these board members disclosing? And if they're not, send them an email, have them disclose. The council refuses to do it. I've spoken with Sally over at the Attorney General's office, who heads the civil division, and she said she'd try to do better, but year after year after year, those councils supplied by the Attorney General's office do not make sure those boards and commissions disclose. If they would do that, that would take care of about half the problem that you've got. The other one is, so again, the Attorney General is just failing on this. The other problem that I noticed, and a potential solution to it, is by the law, it says that if you do not disclose, then you can't occupy the position. I have taken the position before the board and the chair, who is the Attorney General, and their counsel, that if someone does not disclose, they should not be allowed to participate in the meeting. I suggested if they did that, the disclosure problem would be solved. There's some easy solutions to this problem. The Attorney General won't hear about any of it. So I don't know frankly, how you can solve this problem without engaging the Attorney General more constructively, both on the issue of their counsel and of the Attorney General himself allowing people to participate in meetings at the board without having disclosed. I think the disclosures are the solution is obvious, and I think frankly you folks should not have to be dealing with this problem. The problem really lives over at the Attorney General's office. So anyway, thank you for your attention, and keep up the work.
Thank you.
Thank you, Mr. Meckles. All right, and then next we've got Ms. Monet Silva. Ms. Silva, I'm asking you to unmute yourself and start your video. Please welcome, and please feel free to address the commission. Thank you.
Great, thank you so much. Mr. Chair and Commissioners, my name is Monet Silva, and I am the Associate Director with Common Cause New Mexico. Common Cause New Mexico is disappointed in the Commission's decision not to adopt the staff's draft advisory opinion 2022-07 at today's meeting. We were the lead advocate on the adoption of the contribution limits in 2019 and for the enactment of Section 1-19-34.7 of the Campaign Reporting Act, including the text that is now subsection D. The subsection was intended to prevent the use of artificial legal persons, corporations, LLCs, and the like, to evade contribution limits through the arrangements in which the owner of such an entity would first contribute the maximum allowable amount and then would direct the wholly owned artificial entity contribute the maximum amount, which would allow them to go over contribution limits. Based on our knowledge of the intent of subsection D, it is our view that the staff's draft advisory opinion 2022-7 reflects the only interpretation of the subsection, and that is faithful to both its intent and its literal text. And that would allow the subsection to be effectively enforced and not easily evaded. That's it for today. Thank you so much for your time.
Thank you, Ms. Silva.
All right, I don't see any other hands raised, Chair, so I think you can, well, feel free to adjourn the meeting if you
All
wish.
right. And being free to do so unless any of my
Mayor Cliff
colleagues.
Reeves just came into the meeting.
Oh,
If he wants to make a
Mr.
public
Rees, do you have a public comment?
No, commissioners, I just had another call that I needed to take, but thank you for all the great work that you've been doing. Really appreciate it. Thank you very much.
Thank you. Any commissioner have a burning desire to speak, or shall we call it a day? Thanks, everybody, for your usual good service, and I look forward to seeing you hopefully in person on August 5th, but if not, we'll see you online. Take care, everyone. The meeting is adjourned.
Thank you, Commissioners.
Thank you all.